SJC-13315, Commonwealth v. Carlos Guardado.
Thank you, Your Honors. Elaine Fraunhofer for Carlos Guardado. This case raises a number of issues. I'm going to jump right in with where this case began, the search of Mr. Guardado's car. Because it was a warrantless search, it's presumptively unreasonable, unconstitutional, and at the suppression hearing, the government bore the burden of proving otherwise. Because the search was based on an unnamed informant's tip, the government needed to prove the information it received satisfied both tests adopted in Commonwealth versus Upton.
Well, let's put veracity aside, because you've got quite a steep hill there.
Okay.
But the basis of knowledge, I mean, really dig down deep into the transcript, into the testimony, because he said it was real, and tell me why the basis of knowledge isn't satisfied here.
I'll start with what Commonwealth versus Upton says about what you have to establish. And it says the government would need to prove the underlying circumstances from which the informant concluded the contraband would be where he claimed it was. It was, yeah. And here, unlike in cases where courts have found that that test was satisfied, we don't have any information from the informant about, well, he didn't say, Detective Pirouet didn't say he personally observed the firearm. He actually clarified that, well, actually, I just asked him if it was real, and he said yes, and so that was how I came to that conclusion. But saying it's real is no different than saying the gun is silver. It's just another piece of information that would lead with a lot of other information to establish probable cause.
Who's saying it's real? Who's saying it's silver? Who's saying those things?
The informant is saying that.
And so don't the cases say that from that we can infer the informant saw it?
No, because you can infer based on a lot of details, but here are the details that would tell you the informant, again, with the quote from Upton, the underlying circumstances from which the informant concluded the contraband would be where he claimed it was. So the informant doesn't say he saw it. He doesn't say when he saw it. He doesn't say where he saw it. He doesn't say when or where he even saw the backpack. He doesn't say that he knew, or he could predict with any specificity where Mr. Guardado would be at any particular time. There's no information that this information was fresh, such as what Mr. Guardado was wearing. Pirouet said the informant knew his nickname, but he was unsure if he even knew his real name. He didn't know, the informant didn't provide information that indicated he had any particular personal knowledge of Guardado. He knew he worked at an AutoZone, but not where. He wasn't sure if he knew his real name.
Let's really dig down into the basis of knowledge, though, and see whether it's here, because we have the judge's findings, and the judge heard the witness. So there's a question from the prosecutor. Now, related to the firearm, do you know, or were you aware of if Z had actually seen that silver firearm that he or she described to you? So that's the question. There's an objection. And after the objection, the question is, and how were you made aware that Z had seen the firearm? Answer, I had asked Z, is the firearm real? What was Z's response? Yes. He doesn't, the implication is not real like it's a functioning firearm. That's not the context. So is that enough for the judge to make the finding that the judge made?
No, it's not. It's no different. All of the cases the government relies on that establish that there was personal knowledge, which personal knowledge, once you've established personal knowledge, that establishes basis of knowledge. But those cases, I think it's Carrasco and Warren, all involve situations where, those were affidavit cases, where in the affidavit, the officer says, the informant told me he was, at 83 Franklin Street, was talking to the defendant, he saw the gun, he saw the drug, like actual direct information of personal knowledge. Once you're outside of that, then you have to get into the area of, did you provide enough details that would make us believe, that would satisfy, that the informant concluded the contraband would be where he claimed it was? We have nothing in this case. Again, not when, not where, not, what Mr. Guardado was wearing.
But you do have a record on this CI, right? So you know that he has given information that's led to an arrest and seizure. so not just an arrest, but a seizure. To what extent can that compensate for any deficiencies in this?
Well, I know that Justice Lowy said it's a high burden on that, but I do think that it is, in this case, closer to the burden that was not met in Commonwealth versus Melendez, where there was only one prior arrest. And you mentioned that there was a seizure. So notably, in his testimony, what Detective Pirouet said was, there was this one prior arrest, it was a drug case, and narcotics were seized. And then he says, and then the prosecutor asked, and was there a firearm, something about the firearm? And he says, yes, and we found the firearm exactly, I'm paraphrasing a bit here, where the informant said it was. So I do think it's an important distinction because we don't know that, it's clear that if the narcotics had been seized where the informant said they would be, Pirouet would have said that. You know, this, it again, is their burden at the hearing. And I only make that distinction, Your Honor, because I think it's important to not overstate
You're
what...
saying that the seizure wasn't of the narcotics and where the CI said they were, but it was...
We have no
the gun.
evidence of that, and we actually... I'm sorry.
Okay. No, go ahead.
Yeah, I understand. Yeah, I think we have... The government failed to present evidence of that. That's not what Pirouet said. And when the informant had, with respect to the gun, that did not lead to an arrest or even, as far as we know, even any illegal activity.
Can we get to a difficult issue in this case, which is, does the probable cause, if it exists, either made up for by corroboration or otherwise, that there is a gun in a backpack, does that allow for the search of the glove compartment? And obviously, Commonwealth versus Davis, a relatively recent case, suggests that it does, and there's closed container cases where there's probable cause only as it relates to the container. It just by happenstance happens to be in the car that might suggest it doesn't. But that's really a really important and difficult issue in this case.
So I just want to say, the Davis case, isn't that the one where they arrested...
The OUI drugs. Yeah, and
I
they go
thought it
into
was
the
the...
glove
I thought...
compartment.
Sorry.
There's also Commonwealth versus Cast, so you could use.
Yeah.
So
Cass,
Commonwealth versus
too.
Davis
Thank
is the
you.
case, though, where they arrested him for possession of marijuana and then searched the car for instrumentalities of the crime. It wasn't... The search of the car, the glove box wasn't based on
Your
probable cause.
point is it's not a matter search. It's a search incident to arrest as opposed to...
Correct.
Yeah, and Justice Garciano's point about Cass, too. Thank you, with the trunk.
Yeah. So, but in Cast, I mean, the circumstances in Cast are about as far removed from this as you could get. I mean, as I read the cases where the courts have felt there was insufficient evidence of probable cause, we're well below those cases. We are so far from Cast as far as all the details of, you know, he's going to be...
But suppose.
Okay, let's get back to Justice Lowy's question.
yeah,
Sorry, I'll
please.
stay focused.
Yeah.
So, yeah, I would say that here's the problem. Once they get into the car, there's no backpack in the car. That was really a critical piece of information. Like, the other stuff, it's a silver firearm. I mean, most firearms are silver. And you know, we don't really have anything else. We don't have anything incriminating. We don't even know, and I don't want to go on about it, but it's not even clear that it's the informant that fed the police the information about the car. Pirouet said, we already knew about this car, and it was collaborated. So once you get in the car, and there's not even a backpack in the car, they clearly don't have probable cause now to go searching elsewhere where a backpack containing a firearm isn't going to be located.
The judge makes some findings on, I'm looking at A7. However, the evidence was reasonably clear that the empty gun case was discovered before the glove compartment was searched. It could be argued that the collective knowledge doctrine would support the police search of the locked glove compartment using keys obtained from the defendant. You want to address that?
I do, yes. So, I mean, to say that you have probable cause to search a backpack stored in an auto zone based on this tip, I mean, I think it's absurd. Like, it's not in the car. That's what the informant told you. So you don't have probable cause to search a backpack stored in an auto zone, and particularly where the police watched Guardado pull in, watched him leave his car. Nobody saw him take a backpack out of his car.
You're right. Say you're right. They don't have probable cause to search the backpack. They can't just leave a backpack where it is in the auto zone. Oh, well, might be a gun in there. We'll just leave it there. They can't really do that. They pick it up and they feel a gun holster.
Because they didn't feel a gun holster, though, correct? I mean, they felt a box, and you can't, a couple things. They certainly, if they had if they had probable cause to believe that they could search this backpack,
I'm giving you that they don't, for my question.
oh, so they would be entitled, no, they would not. They would not have the right to pick up and manipulate the backpack, that they don't even have probable, they don't have
They
probable.
can't take it and go get a warrant rather than leave it with a possible gun in the auto zone?
Okay, so I'll say, let's just assume that they can seize it
Right,
and go get a warrant.
yes.
They didn't do that. And they don't have any explanation for why they didn't do that. It was not in a car, it's no exigent circumstances. They had about a dozen police officers there. Obviously, somebody could have sat with a backpack.
But when they have that backpack in their hands, if the probable cause that they, at least at one point, there was a backpack in the car with a firearm in it, now you have even more corroboration of that. And the question is, are we to assume that the firearm, X amount of time after the call, can't move to a different location in a car?
Well, I think you're kind of getting ahead of it. You don't have probable cause anymore. It's like the thing that brought you probable cause doesn't exist. When the police cannot corroborate what is the significant detail in the tip, it weakens the probable cause. So, I don't think you had probable cause to begin with, but once you realize there's no backpack in this car, you definitely don't have, and so, but let's even assume you do, but you cannot then pick up the backpack. You don't have a right, you need to have a warrant, or you need to have exigent circumstances. And then we get to, if they picked up this backpack, let's say they could, which, again, clearly they cannot under United States versus Bond, what they feel is a box, like that. I mean, there's a whole host of cases that say you can't then assume that you've got a gun.
Can I ask you, I love talking about these old-timey search and seizure issues, but you raised some really important issues as well on brawn and in place of business.
And I can switch to that, Your Honor.
Yeah, if you would, that would be helpful to me. With respect to in or on your residence or place of business, is it your position that the parking lot was his place of business, so the exemption would apply
That is correct.
to him as well, and it was error not to give that instruction?
That's correct, Your Honor.
We don't have any cases on what that means.
Apparently we don't, yeah. And as, my colleague and I have found that there's actually not even that many cases in the nation, and that there's a split in the cases across the nation that have this exact same language as to whether they include employees or they don't. But significantly, from my reading of those cases that do not include employees, the legislative history indicated that it was for, the exemption was for protection of property interest, and that is clearly not what our statutory history states, as the Commonwealth has acknowledged. Our statutory history indicates it is for self-protection. So other than policy,
And you would say that in or on modifies place of business as well, grammatically, correct?
yes,
So if you have a factory with 500 employees in it, each employee would not violate 10A if they have a firearm in their lunchbox or if they have it in the vehicle?
not 10A.
10H.
Yes, correct, 10A,
They have 10H liability,
right,
right? So it would be a misdemeanor, not a felony, essentially,
yes,
correct?
correct,
So
correct.
it wouldn't be lawful, it'd be just not a 10A violation.
Right. And I do want to make a point about that point that the government raises about how, well, if you allow this, then, hundreds, thousands of employees could be carrying guns to and from work. Well, actually, they can't. This exemption only allows you to have a licensed firearm on the property. You can't actually bring it back and forth. And so in this,
The drive over would be perilous,
correct.
or the walk.
And so in this case, the jury surely could have found that, the officers said they watched him drive in and they didn't see him go to his car. So had they let this issue go to the jury, the jury could well have found him guilty of that.
And I reread Braun, as entertaining as that case is. I didn't find anything in there that says that this scheme would be allowable in a Braun. I mean, I guess what I'm probably, and I'm going to ask Mr. Charles, but what about the government's burden in affirmative defense or the burden of production in Braun.
Okay, so,
Could you address Braun in the burden of production, whether that survives, given that constitutional right of personal protection that we have in Braun?
well, I'm sorry, are we really switching to that issue now? Thank you, sorry. I wasn't sure if we were still talking about the other statutory institutions.
No, I'm done with that one.
Okay. So yeah, Mr. Guardado raises that he's charged with the crime of possession of a firearm, which you have a Second Amendment right to, without a license. And so the jury needed to be instructed that the government prove he was without a license. And we have had this anomaly in our jurisprudence.
And forgive me, the trial counsel asked for that instruction?
He did not, but of course, he wouldn't have been known to do that because Bruin wasn't decided for 6 months later.
And there's a statute, but, right.
Right. I mean, Gauss was the law of the land.
Right.
And that said, you do not have this right. But Gauss was decided based on 1970s jurisprudence when, I mean, there's a whole host of problems with that case, which I think the amicus brief lays out pretty clearly. But, you know, one of the key points is that it was decided at a time when getting information about firearm licensure was actually difficult for the government. Well, now all you have to do is look at the suppression hearing testimony of Detective Lewis, and like that, he was able to find the firearm licensure status. So that issue.
That's the issue of convenience, whether or not the burden
Right.
of production
Right.
provides. Well, what about the constitutional right?
Yeah.
It's an element of the crime now, correct?
Right. And Gauss was very clear about, in Gauss, the defendant raised the exact same issue as being raised in this case, and they said the reason that, that the flaw in the defendant's claim was that it was where he was when he was in possession of the firearm. He was outside of his home, and the Gauss explained that the reason alleviating the government of the burden, this isn't a quote, but it's my notes, the reason there is okay to alleviate the government of the burden of proving lack of licensure, and that did not violate the due process clause is because it at the time it viewed our laws as being a general prohibition against carrying a firearm. And Gauss didn't like push beyond that because it covered he wasn't in his home. So he was in a position where there was a general prohibition against carrying a firearm. Well, now you have Bruin telling us there is no general prohibition. In fact, you have a constitutional protected right to carry a firearm in public.
But Bruin also doesn't, Bruin declares part of the New York statute unconstitutional that sort of puts, but it's not a burden of proof type of issue, is it? Bruin leaves open the possibility of having all kinds of licensing schemes. They just didn't like the sort of, you know, the one that the AG has fixed here, or at least tried to fix here.
You're right, but what it does say is it breaks the only justification that was given in Gauss for not including the instruction not putting the burden on the government to prove what is clearly an element of the crime. They rationalized it as saying, well, it really is always a crime because you're generally prohibited from carrying a firearm.
The chicken and egg, I mean, Bruin still leaves clearly open the possibility of licensing schemes, right?
As far as I know, yes. I mean, that's my reading of it is that there might be issues in the Massachusetts statutes that I have not uncovered.
They just don't like these sort of unbridled discretion. I don't like the.
Right.
I don't like the.
It's a shall issue, but isn't it? It's a due process issue, correct? As far as burden of production and an element of the crime.
Correct, right. So separate and apart from whether Massachusetts has a lawful or unconstitutional firearm licensure scheme, it's a due process question of whether, you know, at the end of the day, Gauss has recognized that it would, you know, and I'm sort of quoting from this Patterson versus New York Supreme Court case that Gauss quoted, that it would go beyond constitutional limits to permit nothing more than proof that a citizen committed an act that they have a constitutionally protected right to engage in as proving they've committed a felony.
And let me ask you one more question, going back to the search for a minute. If you win that point, these questions are moot, correct?
They are, but I hope your honors address them because you're right, they're very interesting questions. And I just wanted to say a couple other things about the statutory interpretation on place of business, and that is that...
Along those lines, because now you're stepping back again to the other issue. You said that you looked at cases around the country. So let's just assume, for the purpose of my question, that employees are covered. And while it'll be a crime to bring their lunchbox into the car and drive there, if they're caught in the factory or even in the factory parking lot and they've got the firearm in the lunchbox, well, let's assume that that's protected and they'd have to be prosecuted not under the mandatory minimum, but for the misdemeanor. Why is it that we now are going to take that principle and apply it to all these parking lots that the public has access to in a huge shopping center, let's say, where there's absolutely no exclusive control of the employer or the place of business of the employee?
So I just will point out that I believe it's the case today that you can get a license, and do that. You could have a license to carry, and you could bring your firearm with you to work. So,
Right.
I'm sorry.
Yeah,
Correct?
okay, yeah.
Yeah. So so I'm just going to say it's not as though we're venturing into some wild territory. Today, you can have employees coming in carrying weapons, right, to and from. And I'm sorry, I actually have lost track of your question.
No, that's okay. It's really simple. Why are we going to take that language and apply it to public parking lots?
Well, I think that there are other statutes that would, so, again, this gun was in a locked car in a locked glove box, which actually might touch on whether he had exclusive control, which is an aspect of this. And it's not like, I actually don't know this for sure, but I'm assuming that you can't leave a gun out in a parking lot that anybody could pick up. Like I'm just going to assume that there are protections from that in storage, proper storage of firearms and so forth. So I think that might mitigate the concern that you're raising, Your Honor, that there is a scheme that covers all these things. If you're an owner, you get to do this clearly. I think nobody disagrees on that. And now the only question is, well, what if you're the employee? And there are other ways that these things, the public is protected. And the other thing I'm just going to mention is that when you think about, again, if we're all in agreement that the statute was put in and phrased this way for self-protection, it is more likely that it is the common employee that needs self-protection. When you think about, the clerk working the midnight shift at the convenience store, who's the more likely person to need self-protection? And I think Bruin's decision actually emphasizes that point. The Second Amendment protects every citizen's right to self-protection.
Okay,
Am I over time?
way over time. So I think you've satisfied all the
Thank
questions
you, Your
we
Honor.
have. Thank you very much. Okay, Attorney Charles.
Good morning. May it please the court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth.
Can you explain why it was okay to go into the glove box?
Yes. Well, there's two separate avenues by which this court could conclude that it was appropriate for law enforcement to go in the glove box. The Commonwealth's position is that preliminarily, even prior to the discovery of the backpack in the auto zone, there was still probable cause to go into the glove box, and for the following reason. As the Commonwealth alluded to in the Cass case, the court recognized this distinction between the instances that my sister cites to in, say, Guardado or Moses, where you have a contemporaneous observation of some act. I believe in Guardado it was the odor of burnt marijuana. In Moses it was furtive movements of a car's occupant ducking down below their seat. In those cases, because there was a contemporaneous observation of an act that provided the justification to go in the car, the search had to be limited to the area that was within the reach of the person who was observed. Or in the case of the burnt marijuana, this court concluded it would have had to have been from, say, a joint that was being smoked, so it wouldn't have been in the trunk. That is distinguishable from a situation here where we have a tip that, yes, there is a gun within a container, within, for lack of a better term, another container, a car. But then there is a time gap between that tip, at which point the car is not under observation, at which point no one has any eyes on it whatsoever, And as this court observed in Cass with respect to the large suitcase that was placed in the vehicle right before police lost sight of it, it's possible for things to be moved around. So, and to put a slight wrinkle on the facts, if the tip had been the firearm is in the center console of the car, or the firearm is in the back pocket of the passenger seat, we would not say that if, again, there was a 2 or 3 hour gap where no one had eyes on the car, the police could then only search that one single location in the car. We would say, obviously, people move things around. No one has eyes on them. No one knows what they're doing. We
Right,
still
but
have.
isn't this an elephant in a matchbox kind of case, too?
I disagree with that as well. Again, the Commonwealth provided a supplemental record appendix with photographs of the backpack. Now, granted, no one understood what the backpack was beyond that it was a black backpack, but if you see the backpack that was found, it is a soft shell, malleable backpack, and you see the size of the glove compartment. I would submit that it's reasonable to conclude that someone could have shoved that backpack with a gun inside into the glove compartment because it's not a hard case. But still, can it fit in there? And so if it's possible for it to have fit in there, then that would be sufficient. But that's only if you're assuming that they have to be limited to places where the backpack could be found. And again, it's the Commonwealth's position that pursuant to Cast, I agree with my sister, the facts of this case are not the facts of Cast, but the principle enunciated that where there is this lack of observation in the interim, where we're not talking about contemporaneous observations, you have to accept that people can move things around within the vehicle. It happens. So this idea that they would be limited to the very specific place that 3 hours ago the gun had been within the car is not what the case law provides for.
Now, when the chief asked you the question, you said there's two ways to get there, and your other way is the collective knowledge issue. And the appellant is saying that there's no way that you can even touch the backpack, so you never get to the collective knowledge issue.
So again, I would disagree for several reasons. First, I think there's clearly probable cause because they learned from an employee that this is a black backpack that is the property of Mr. Guardado. And again, the tip was that the firearm was in a black backpack. Again, yes, within a car, but I think that where an officer contemporaneously is going into the store, he does not know what's going on in the car at the moment. He sees a black backpack that is the possession of Mr. Guardado. He has probable cause to believe it may contain a firearm.
So did that
and to
extinguish the
seize it.
probable cause for the car at that moment, and then it's recreated when you look in the backpack?
Again, that's an interesting question. It's sort of a situation that I don't think has been previously addressed in the case law. I think what is crystal clear is that the area where the firearm was ultimately found in the car was not searched based on the judge's findings prior to the discovery of that empty gun case in the backpack.
Okay,
So
but do
even
you
if there
have
was a
probable
brief
ca-
extinguishment,
Okay.
it was not a search that prejudiced the defendant in any way because they didn't discover the firearm in the backpack based on the judge's findings.
I understand that. I'm just wondering if you can have probable cause for two different locations at the same time.
So again, I do think you can. I think the understanding was that it can be true that there is probable cause that the firearm was in a black backpack. At the same time, it can also be true that the individual may have moved it out of the backpack into some other location within the car. There's just this temporal gap in which the defendant is unaccounted for, no one has eyes on him, and we don't say that the tip is therefore stale because they find him 2 hours later. I think Cast makes that crystal clear, right, with respect.
Your guns can last a little longer than 2 hours, right? But with this, what would have kept them from just setting up? They've got officers set up a surveillance or set up secure perimeter around the car and go get a warrant. Why can't they get a warrant in this case?
Well, it's not a question of whether they could get a warrant, it's whether the law permits them to conduct a search without a warrant. And I think the automobile exception clearly
Yeah, but if
permits
we
that
move
to
into the
happen.
automobile exception for any reason, I don't know if we want to, but
Your position is there was probable cause to search for a firearm, and MATA allows you to search for a firearm.
Yes. Frankly, the Commonwealth doesn't see it as a particularly close question. I mean, there was a reliable tip from a confidential informant. The case law is clear that that provides probable cause to search for a weapon. And here, the weapon was found in the automobile, that it was permissibly searched without a warrant pursuant to the automobile exception.
Can you tell me why the burden of production survives Braun or Bruin or however it's pronounced?
So, yes. I would simply say my sister focuses heavily on Gauss, as does the Amici, who, frankly, I just want to note, are making a slightly different argument than my sister is making, which the Commonwealth had limited time to respond to because the amicus brief was filed after the Commonwealth filed the substitute brief. I'd also just want to note before I answer your question that none of these issues were raised below by the defendant, pre or post conviction. This issue was added to the brief when it was
Okay,
transferred
now
to
with
the
those
responsible-
caveats, in the answer to
So,
Justice Gaziano's
yes.
question.
In McDonald, Gauss did concern a search that was outside of the home, and McDonald did deal with searches inside the home. However, cases like Lodeholt and Powell, which post-date McDonald, which are cited in the Commonwealth's brief, did concern searches in the home that would have been implicated by the McDonald decision, saying you have a constitutional right to possess there. And this court still found in those cases that it was appropriate for the burden of production to be on the defendant, that it was an affirmative defense. As recently, in fact, as I believe it was 2019 in Harris, this court continued to find that this was not a due process violation. So given those post-McDonald decisions, it lends itself to the parallel conclusion that Bruin doesn't alter that analysis. As Justice Kafka acknowledged, and as Justice Kavanaugh noted in the concurrence in Bruin, states are still permissible to enact strict firearms regulations. They just have to be objective.
But that has nothing to do with the burden of production and proving a case. Regulation is still alive and well. You just can't have a may issue. You have to have a shall issue.
Again,
statute.
in McDonald, the Supreme Court stated that you have a constitutional right to protect your home with a firearm. Post-McDonald, this court was untroubled with its allocation of the burden and continued to find
But you would
that-
agree that possession of a handgun in public is a constitutionally protected right.
Yes.
And the defendant's failure to obtain a license is a necessary element of the offense.
Again, this court has not characterized it as the point is,
The crime is unlawful possession of a firearm, not possession of a firearm.
well, possession of a firearm can be unlawful in a lot of different ways, not just with respect to possession of a license. So there are a variety of ways in which a defendant can violate statute. I mean, some defendants obviously can't even possess a license. So
I'm
I think
confused by that. So I understand possession of a handgun is outside of the home is now a constitutionally protected right, but it may also be subject to a licensing scheme.
that's the point that
And if it's subject to a licensing scheme, I don't know if the Supreme Court has weighed in either way about who has the burden of proof of whether you've complied with the licensing scheme, right?
Well, under Winship, though, the Commonwealth needs to prove a crime. And if it's a constitutional right to bear an arm in public, you need to prove a crime.
again, I think, and I was inartfully answering your question
Is it
before,
a
Justice Gaffney.
constitutional right to bear? It's a constitutional right. The definition of the constitutional right incorporates a proper licensing scheme. It's not, we can't just all run out and take handguns out and run around. The state can impose a licensing scheme as long as it's a constitutionally compliant one.
Correct, and that's why I don't, sort of in rebuttal to Justice Gaziano's comment before, the Commonwealth does not view them as distinct issues, because you do have a right to use a gun for self-defense. At the same time, states have the right to heavily regulate that and require that you have it.
You agree this is a due process issue, correct?
Yes.
Does the due process justification go away because it's now no longer a matter of convenience where the state can go to CJIS and push a button and find out whether or not someone's licensed?
I don't know if it's specifically because of that, but I think there's a vast overstatement of what a burden this is on a defendant. In reality, no one's getting, I haven't seen a case where someone has been charged.
Possession, some of the misdemeanor cases in the BMC and district court on, driving an unregistered car. The government has to prove there's no registration, correct?
Yes,
All
the
right.
government does.
Right. And when you read the burden of production cases in the firearm, they seem anachronistic to me, that the government now has to go through its card catalog and figure out who has a license. That's no longer the case.
I'm not sure I'm following your question.
Because part of the burden of production on this due process dance is whether or not it's convenient for the, who has the, it's a matter of, is it so burdensome on the government? And the rationale is, well, Mr. Defendant, if you have a license, show it. That's the justification for this, right?
Correct.
The underpinnings of it. Isn't it now a matter of, Mr. DA, get a certificate from CJS?
Again, I agree that that is what the government would have to do. I still think that if you look at this court's treatment of cases that involve 10A violations post-McDonald, this court was not troubled from a due process perspective by the continued allocation of burden post-McDonald. And I don't see a distinction other than the public versus residents distinction that would justify deviation from that case law here. No one is getting charged with 10A if they have a license in the first instance. And if there is a questionable issue of license, all a defendant really has to do is just proffer a scintilla of evidence, and then the government now possesses the burden of disproving that beyond a reasonable doubt.
Can I ask you to explain that? You said no one is being charged of a violation of 10A who has a license.
Because they can push the button and figure out if they have it.
Right, I guess that's what Justice Gaziano just said is the due process elephant in the matchbox, if I'm using that correctly. Isn't that,
at the risk
it
of-
seems like the administrative burden justification of Gauss no longer exists. And I understand your point about McDonald and Holmes, but maybe we should revisit that, and tell me why not, given that you can just push the button now.
So again, at the risk of dodging, I don't think you should revisit it in this case. It was not directly briefed by the Commonwealth. It was not raised below. It was raised in the amicus
So
brief
you're back
at the
to your
last minute.
caveats.
And it's not caveats, and I believe I've stated the Commonwealth's position, and I believe that the rationale for this court's
Right.
post-McDonald case law
what-
stands. So
What was raised is the whole place of business instruction.
yes, and I
Okay.
would like to address that.
Please, so you agree that in or on modifies place of business as well?
Yes.
Okay, so what does it mean?
So I'm not sure this court even necessarily needs to be concerned about what in or on means, because I think that this court should interpret place of business to only stand for the proprietor of a business and not a common employee, which would substantially reduce.
Doesn't that
How do
seem-
we get there if we agree with you?
Well, I think it's helpful in looking at it and looking at the arguments the Commonwealth makes to look at what other jurisdictions have said. And the Commonwealth cites cases from 8 other jurisdictions that have interpreted substantially similar language to the language at issue here, that have found that it only that is a possessive terminology, his or a person's residence or place of business, and that it only connotes proprietors.
Is that the Commonwealth's strongest argument, though? Because your opposing counsel mentions that the rationale in these other jurisdictions were to protect the property and not what we fundamentally hear for personal protection. What I found to be most compelling, though, are the statutory constructions that we have here about the other portions of the same statute that define that term and define it as the proprietor, the business owner. Can you talk about that?
Yes, I can. And so I wasn't trying to suggest that that was the strongest of the only, and I was getting to that portion of it. And if you look at, for example, the Carr case and the Vickers case from Connecticut, they sort of rely on this same idea of, and if I'm misunderstanding your question, I apologize, but that there are other portions of the regulatory scheme
That's exactly it.
that would be rendered superfluous if we view this as applying to all common employees at a business. There would be no need to exempt police officers or individuals who work at banks or institutional lenders in limited circumstances, or individuals who work on movie productions or other theatrical productions. All of that language would be completely superfluous to the statute, to Chapter 140, I believe it's 129C. If employee meant anyone who's working a job, period. There'd just be no need for it. So, and one of the common canons of statutory construction is that we have to give meaning to every word in the statute and all related statutes, and it would run afoul of that.
But I'm confused then. So if the clerk working the 7-Eleven he would have to, or she would have to have the proprietor's gun, or is she totally unprotected because it's not her store?
Well, first I would say they're not totally unprotected. I think there's two responses to that. The first is get a license, which is clearly the preference of Massachusetts legislature given the strictest gun control regulatory scheme in the country. We want to prevent people who are not trained in using firearms from using them in a manner that's going to harm other people. So that's number one. You can get a license. If the owner wants you to be able to handle a firearm, you can get a license. Number two, I would say, as an employee of a business, it is not your job to, quote unquote, protect the business. As Bruin recognized, everyone has a right of self-defense everywhere. I have a right of self-defense whether I'm in my house, whether I'm at my business, whether I'm on a public sidewalk.
But I'm just trying to, again, the owner under this statute would, without a license.
Yes.
But
Well, he just wouldn't be subject to 10A.
He would, correct. He wouldn't be subject to 10A. And I think which I was trying to get to just now in a long-winded manner is, there is a distinction between the general right to defend yourself and the right to defend your property and your livelihood. So the legislature has recognized the distinction for people who are in their home, where their possessions reside, where their family resides, or people who are the proprietor of a business that are protecting their livelihood. That is distinguishable from the first-year associate at Holland & Knight, or the bank teller at Bank of America, or the AutoZone employee who's fixing someone's windshield wipers.
So now I agree with you, but what do we do with or on? So they could have just said present in his residence, in his place of business, but they say on.
That's fair, and I think that would still be relevant to the extent that you were a business proprietor. But again, I think you can look to the language in the cases that have interpreted residence, and as I apologize, either Justice Lowy or Justice Kaffer were alluding to the idea of exclusive control. In or on your residence sort of connotes a broader scope than just the actual residence, because you may have exclusive control over your backyard, you may have exclusive control over your garage. It is almost never going to be the case that an employee or an owner of a business has exclusive control over a large public parking lot to which customers and other people are coming and going on a regular basis. That's just not a location over which you can have exclusive control. And furthermore, if the rationale is for protection of the property and yourself, you're also just not going to be able to do that if the gun is out in a car in the lot and not in the business proper where the business is being conducted. That's sort of a secondary argument, but I just think this lack of exclusive control defeats the argument if we're talking about a business lot. And although Massachusetts hasn't directly in the residency context addressed a common parking lot, I cited two cases in Texas and Florida that have sort of found that this idea of a common parking lot at a condominium, for example, would not qualify as, your residence because other people have simultaneous joint access to it.
Mr.
And that's
Charles,
always going to be the case.
You're way over time, and I just want to see if the Chief would indulge one quick other question, which is, thank you. Where's the basis, if you can give a cogent answer to this, where's the basis of knowledge of the informant based on the transcript and the judge's findings?
Understood. That's on page 15 of the motion transcript. And again, I think it's important to note how the motion judge's findings read. The motion judge, this is at record appendix 37, notes, the CI said he had specific knowledge of the firearm being in the black backpack because he saw it there and confirmed to Lieutenant Pirway that it was real. So the motion judge clearly viewed these two separate answers as complementary and not clarifying. If you look at page 15, now related to the firearm, do you know or were you aware if Z had actually seen that silver firearm that he or she described? answer, and Z had. So yes, he had seen it personally. The
No
defendant
motion
then
to strike.
objects.
No motion to strike.
No motion to strike, no striking by the judge. There is an objection, and the objection is to the witness's basis of knowledge, not the CI's basis of knowledge. And then, admittedly, an inartful question is posed by the prosecutor at that point, to which the witness responds that he posed a question to the CI, and the CI indicated, yes, the firearm was real. But that doesn't discount the earlier answer, which was not struck and which on the motion judge clearly relied. Candidly, if the motion judge had gone the other way, I'm not sure I have an argument that he was clearly erroneous, because it's such a high burden, but that's not how he interpreted the facts. And given the clearly erroneous standard, I really don't, and what the record shows and the lack of a striking motion as to that testimony, I really don't see how the defendant has a leg to stand on to see that this is a clearly erroneous finding. You may disagree with it, but that doesn't make it clearly erroneous, as this court and the appeals court tell me all the time when I try to argue those points. So if there are no further questions, I'd ask that you affirm the denial of the motion to suppress and the convictions. Thank you.